COPWATCH, policing the police every single day.
The 2021 Florida Statutes. Title XLV. Torts. Chapter 768. Negligence. View entire chapter. 768.295 Strategic Lawsuits Against Public Participation, SLAP, Prohibited. 1. It is the intent of the legislature to protect the right in Florida to exercise the rights of free speech in connection with public issues, and the rights to peacefully assemble, instruct representatives, and petition for redress of grievances before the various governmental entities of the state as protected by the First Amendment to the United States Constitution and S5, Art. I of the state constitution. It is the public policy of the state that a person or governmental entity not engage in SLAP suits because such actions are inconsistent with the right of persons to exercise such constitutional rights of free speech in connection with public issues. Therefore, the legislature finds and declares that prohibiting such lawsuits as herein described will preserve this fundamental state policy, preserve the constitutional rights of persons in Florida, and assure the continuation of representative government in the state. It is the intent of the legislature that such lawsuits be expeditiously disposed of by the courts. 2. As used in this section, the phrase, or term, a. Free speech in connection with public issues means any written or oral statement that is protected under applicable law and is made before a governmental entity in connection with an issue under consideration or review by a governmental entity, or is made in or in connection with a play, movie, television program, radio broadcast, audiovisual work, book, magazine article, musical work, news report, or other similar work. B. Governmental entity or government entity means the state, including the executive, legislative, and the judicial branches of government and the independent establishments of the state, counties, municipalities, corporations primarily acting as instrumentalities of the state, counties, or municipalities, districts, authorities, boards, commissions, or any agencies thereof. 3. A person or governmental entity in the state may not file or cause to be filed, through its employees or agents, any lawsuit, cause of action, claim, cross-claim, or counter-claim against another person or entity without merit and primarily because such person or entity has exercised the constitutional right of free speech in connection with a public issue, or right to peacefully assemble, to instruct representatives of government, or to petition for redress of grievances before the various governmental entities of the state, as protected by the First Amendment to the United States Constitution and S5, Art. I of the state constitution. 4. A person or entity sued by a governmental entity or another person in violation of this section has a right to an expeditious resolution of a claim that the suit is in violation of this section. A person or entity may move the court for an order dismissing the action or granting final judgment in favor of that person or entity. The person or entity may file a motion for summary judgment, together with supplemental affidavits, seeking a determination that the claimant's or governmental entity's lawsuit has been brought in violation of this section. The claimant or governmental entity shall thereafter file a response and any supplemental affidavits. As soon as practicable, the court shall set a hearing on the motion, which shall be held at the earliest possible time after the filing of the claimant's or governmental entity's response. The court may award, subject to the limitations in S 768.28, the party sued by a governmental entity actual damages arising from a governmental entity's violation of this section. The court shall award the prevailing party reasonable attorney fees and costs incurred in connection with a claim that an action was filed in violation of this section. 5. In any case filed by a governmental entity which is found by a court to be in violation of this section, the governmental entity shall report such finding and provide a copy of the court's order to the Attorney General no later than 30 days after such order is final. The Attorney General shall report any violation of this section by a governmental entity to the Cabinet, the President of the Senate, and the Speaker of the House of Representatives. A copy of such report shall be provided to the affected governmental entity. History S1, CH 2000 to 174, S1, CH 2015 to 70.
Thank you. Cool.
That being said, this is still my last opportunity to address the City Council as presently constituted. And I wanted to thank you for your patience and understanding as it relates to the adoption of the new sign code. What gets lost in the debate as to whether or not using the F word on a sign that's visible by children is protected by the First Amendment is that since 2015, when the U.S. Supreme Court adopted its decision in Reed versus City of Gilbert, our previously existing sign code, which was based on content-based categories, was viewed to be unconstitutional because it was an infringement on free speech. In order to be constitutional, the U.S. Supreme Court has said that the ordinances relating to signs needed to be content neutral. And so the code that you adopted, obviously with debate as you went through the process, makes it much greater opportunity for speech to be presented on the signs that are within the city of Punta Gorda, particularly, for example, with respect to political signs. And so rather than repeal the ordinance as was suggested earlier this morning, the ordinance that you adopted greatly expands the rights of free speech within the city of Punta Gorda, and I think you should be commended for that. So thank you. That's all I have.
I was asked a question, as long as we're on this subject, is there any way to pursue civil action against the people who are blatantly opposing the sign ordinance and being continuous disruptions? Well, all right, so the immediate answer to your question is no. The disruptions that you may be referring to, from what I've heard during our staff meetings, for example, are more in the nature of verbal disruptions, not necessarily with respect to the signs that violated our sign code. To my knowledge, there has been no further violation of the sign codes by the two people who received orders against them by the Code Enforcement Board, which are now on appeal. And so to the extent that there aren't any new violations of the sign code, and that's now in the court with respect to their challenge that our ordinance is unconstitutional, we'll ultimately get a decision by the court with respect to that. A motion to stay enforcement against those two individuals will be presented to the Code Enforcement Board at the next Code Enforcement Board meeting. In view of the fact that it's now really in the courts, we'll be recommending to the Code Enforcement Board to grant the stay as it relates to those existing violations. And there's two new violations that were made prior to the notice of appeal being filed, which we're going to continue until after a decision is rendered by the courts. That saves the city additional legal fees and what have you. Certainly the city will enforce any new violation by those gentlemen or anyone else, which is a violation of the sign code, which in fact remains lawful until a court of competent jurisdiction decides otherwise. So I've talked briefly to the police department about the opportunity to deal with disruptions, public disturbances, for example, which are unrelated to the sign code. And so if there's a need to be more aggressive with respect to the enforcement of public disturbing the peace. That can still be done, and again, that's not related to the sign code, that's related to verbal expression, which our ordinance does not address.
I ask that for a number of reasons. There is one group that has a church service in Gilchrist Park every Sunday, and the church service has been disrupted, blatantly disrupted, on a couple of occasions. I understand that police would have to be called and they have to witness it firsthand before they can do anything about it. That's one instance. We had the instance at the school where the signage was outside the school entrance, and we also had one over the weekend for an hour on one side of the bridge and an hour on the other side of the bridge with a fetus picture. And I'm sorry, I just think that we're breaching the acceptability threshold.
Well, as the city attorney, I can only advise that there is a fair amount of free speech that is in fact protected by the U.S. Constitution. I've simply advised the city council that with respect to obscenity as we've defined it, which is based on case law, fighting words as we've defined it, as based on case law, and indecent speech as we've defined it, those are the areas that I think we are comfortable in regulating, because the courts have said those three categories, although it may be content-based, are clearly not protected by First Amendment rights. Other things that we might find distasteful, however, are protected.
Okay.
Now, there may be, one of the things we were talking about is regardless of what's being said, if someone's on a bullhorn that's turned up, say that 6 blocks away, it's waking people up, and I'm being very facetious, but does that disturb the peace in some manner, regardless of what's being said, aside from the discussion of the content of what's being said? Is there something that's too loud that we can try to prevent if that occurs? And that's a whole different discussion, I believe, than this.
Okay.
Thank you.
Okay, thank you. Okay, under council member comments, I have a few things.